Yes, good afternoon, ladies and gentlemen. Thanks for joining us this afternoon. My name is Timothy Kaja. I'll be your moderator for the afternoon. Let's just give it a few more minutes to have our members settled in, and so for our panelists to join us. So let us just give it about 5 minutes and have everyone settled in, and then we can be good to go. Thank you. So let's just hold up a little more, so we have everyone settled in.
No, I'm saying where can I go to physically, because it's in my big place.
Anywhere to sit.
Yeah.
From the other side. So it's basically her who's not been able to do what she's supposed to do from her end, but we are still pushing her.
All right. Good afternoon once again. I'll request us to keep our microphones mute. Yes, thank you very much for being with us this afternoon. Your moderator for the day. My name is Timothy Kaja. I'm a lecturer of law at Kampala International University, Uganda Christian University, and Chambogo University. I'm also a member of SIAP with a specialization in sports law. And I also serve as the director at Discovery Sports Uganda. But today is not very much or anything about me. It's about us learning two sensitive areas and how they interact with arbitration. And these two key areas for the day are, one, artificial intelligence, that we often love to summarize as AI, and intellectual property, an area that we have dealt with for decades. Now, there has been a growing pattern indicating that these two items are increasingly interacting with arbitration. And here, today, we are going to be joined by two esteemed panelists to help us break those two items down and how they relate with arbitration. But for starters, before we get there, I would wish to call on our host for the day, SIAB Uganda chapter, presented by Ms. Anne, to just give us about only a minute of her introductory remarks, and then we can go on to know more about our panelists. Anne, please, for a minute, the floor is yours.
Thank you, Timothy. Good afternoon, everyone. I hope you can hear me.
Yes, we can hear you, Anne, loud and clear.
Okay. Good afternoon to our dear participants, and I would like to warmly welcome you on behalf of SIAB Uganda chapter to our first event of the year, a webinar on AI and IP and arbitration. As Timothy has mentioned, we're going to be led by a team of seasoned experts that shall take us through, and I know that by the time we finish this, we shall have learned lots about the intersect between the two and arbitration. So thank you so much, and kindly follow us on all our platforms because we have very exciting events lined up for you this year. My name is Anne Namara. I chair the Education and Training Committee of SIAB Uganda chapter. Have a very insightful webinar. Thank you, Timothy, and over to you.
Yes, many thanks, Anne. As you learn, this is our first for the year, but many are following up. Just keep up with our social media pages to learn more. Of course, even in our WhatsApp groups, we keep sharing these on different platforms. Just pick up on those, register, and learn more with us this year too. But back for the day's main event, like I said, we're joined by two experts, and allow me to read out their profiles. Of course, those who have joined in early would have been lucky enough to see the videos running with them. But number one is Dr. Anthony Kakoza, who is currently a partner at Bientia Kihika and Company Advocates, and in charge of the company's intellectual property practice. He's also the acting head of commercial law department at Makerere University Law School here in Kampala, where he teaches intellectual property and cyber law. He is a visiting professor of intellectual property at the University of Illinois in the USA and Shandong University in China. He was previously a visiting professor at Cornell School of Law, still in the US, Massac University in the Czech Republic, and the University of Rwanda. He's currently the chair for the IP cluster of the Uganda Law Society, and he undertakes consultancies for URSB, ARIPO, and the World Intellectual Property Organization, WIPO. Very nice to have you here, Doctor. Doctor, if you're in, you can please send brief greetings to our listeners this afternoon.
Thank you, Timothy. Good afternoon to our listeners. I appreciate SIAB giving me this opportunity to be part of this webinar. And thank you. I look forward to a brilliant interaction this afternoon. Thank you.
All right. We are not out of superstars to run the show for the afternoon. The second panelist is Mr. Robert Chirunda. Robert is an advocate of the courts of judicature in Uganda, an arbitrator with the Chartered Institute of Arbitrators. His experience and expertise in legal practice is rich in both breadth and depth. Robert has an impeccable record as an excellent litigation lawyer, handling high-value strategic litigation disputes. Robert has specialized knowledge in modern financial markets, tax practice, and emerging technologies. He advises clients on complex multi-sectoral transactions, offering pragmatic and commercially focused and astute perspectives. He has advised and participated in national policy formulation and progressive law reform projects. Robert teaches at Makerere University School of Law and is the convener of the Center for Law and Emerging Technologies. He also heads the arbitration cluster of the Uganda Law Society. Nice to have you, Robert. Robert, could you confirm that we can have you loud and clear?
I confirm, and thank you very much for having me. Good afternoon to everyone on the call.
All right. That is very good to confirm that we have both our panelists here in time. So let's get straight to it. Probably we'll start with you, Dr. Benjuback, by simply telling us who may be new to this. Simply, what is arbitration?
Thank you, Timothy, for that. It's a good start to this webinar, understanding the key areas that we're talking about. Simply put, arbitration is a resolution of a dispute without the need to go to court, except when it comes to enforcement of the award that is issued at the end of the dispute resolution. But what is really crucial to note is that arbitration is a creature or can be a creature of contract. So the parties have to agree as a term within the contract that in the case of a dispute arising out of their business relationship, this will be resolved through arbitration. So that's the simple understanding of what arbitration is.
Thanks for that precise breakdown. And to bring in Robert, we hear that there's something called alternative dispute resolutions. We hear of many forms. We hear of mediation, we hear of conciliation, then arbitration. Are they one and the same thing? Are there differences, if any? Could you please share that with us? Yes, Robert, are you still with us?
So the mute had me there, sorry. Thank you, Tim. Yes, can you hear me?
Yes, we can
Timothy,
hear you loud
can you
and
hear me?
clear. Yes.
Hi, Timothy, can you hear me?
Yes.
Wonderful. So I was saying that, lovely. So I was saying that there are differences between the various modes of alternative dispute resolution that you just outlined. Mediation being the first that we should distinguish. So arbitration is basically like court only, it's private party led. You don't have a government involved, except as Professor Kakoza has said, at the point of execution. Parties have picked their judge, they put the dispute before him or her, and that person resolves the dispute one way or the other. But it is still adversarial. Mediation, on the other hand, is basically a negotiation in which nothing is agreed until the parties say so. Now, the process is confidential, like with arbitration. However, what comes out of mediation is not a binding award. What comes out of mediation, sometimes, depending on how the process started, will be a settlement agreement or some sort of consensus between the parties. If the mediation starts, for instance, as part of a court dispute, then what's going to come out of that process will be a consent judgment. So the result in mediation is an agreement, while the result in arbitration is an award, which is enforced like a judgment of the court. Conciliation, on the other hand, is even more, so one way to look at it is conciliation is slightly more informal. You don't have strict rules of procedure applying. The parties are aiming at resolving the dispute as amicably as possible without having strict rules of procedure and of law. Whereas in arbitration, those rules will apply. So for the lawyers on the call, the procedure in the courts will be governed by the civil procedure rules. In arbitration, the parties will agree what rules are going to govern them and then reduce those procedural steps into procedural orders, and those orders are just as binding. Once a procedural order is signed by the arbitrator, it is basically going to sort of take the place of the civil procedure rules, which do not apply in mediation or in conciliation. Now, adjudication, on the other hand, is still a situation where, and is even much more common in construction. I think lately the growth has been in construction. You still have two people or two parties or more with a dispute, subjecting it to an independent party to arrive at what they would believe to be a fair outcome without necessarily going about it the way that we lawyers would go about it. Can lawyers be adjudicators? Yes. But does an adjudicator need to be a lawyer? No. So for instance, you would have a structural engineer at a site who says, I have looked at this from a technical perspective. This makes sense. This doesn't make sense. It's usually in construction used to make sure that the project doesn't stall. If you think about how long an arbitration takes, arbitration will go months in the very least. The complex ones may even go over a year. A construction site where you have a dispute and everything grinds to a halt for a year is going to be a very expensive site. So what's going to happen is the parties will say, no, let's get a structural engineer to resolve a technical question. Or let's get an architect to answer the question so we can all move on and perform the contract. So the objective in these alternative methods of dispute resolution is basically to speed up the process, to allow the parties to proceed either semi-informally or in a structured way, but to arrive at, except in arbitration, to arrive at an amicable solution. While in arbitration, you're still going for an adversarial system, an adversarial approach, but arriving at a final outcome potentially faster than you would in the courts. I think I'll leave it there for now.
Thanks for that detailed breakdown, Robert. Now I think we have a fair understanding of the concept that we're dealing with. But to go back to Doctor, we've heard, of course, arbitration, what it is and what it is not, but what other modes there could be. But then how does IP come into this? And do they relate? Are these things that we can mix up or one can superimpose over the other? Help us connect intellectual property and arbitration, please.
Okay, thanks. So intellectual property, as well, in simply understanding it, is the creativity of the mind. Anything you create that, if it leads in one way or another, is intellectual property. By saying leading in one way or another, you may create a piece of music that leads to copyright as the intellectual property right that comes from it. If you create some sort of technological solution to a problem, then you're creating an invention which is patentable, or depending on what criteria you fulfill in the direction of a technological solution, you may get a utility model or an industrial design if you're not focusing on what it does, but what it looks like. And there's a lot of there are a lot of synergies between intellectual property and arbitration in this regard. But the key relationship is in utilization or using. So the utilization of or dealing intellectual property rights is not just about the end user, the person who enjoys the piece of music or the movie, which is copyright, or the person who uses the invention, which is the patent, but also involves contractual undertakings that cover the issuance of a license or an assignment of an intellectual property right. So take, for instance, in the copyright industry, it is pretty much impossible for a music or a movie owner or a book author or publisher to follow up on every Tom Sanjay, Dick Soka, and Haruna. I mean, I would rather use the local names than say Tom, Dick, and Harry, who is using their music, movie, or book. So what they do is to assign their copyright to what is known as a collecting society or a collective management organization to manage their rights for them, including collecting the royalties for their use of their works. So in case of a dispute arising, arbitration is the best way to go in resolving such a dispute between the copyright author and the collecting society that he belongs to. And this is actually covered in legislation. So when you look at the Copyright and Neighboring Rights Act, Section 78, Cap 222, which is to the effect that any dispute between a member of a collecting society and a member, or rather between a member of a collecting society and such a society, has to be resolved through arbitration. So when you have such a statutory provision, then you're not going to go anywhere else. You just know that arbitration is what they would have to use in resolving their issue. So then also outside of the involvement of collecting societies, I actually acted as an arbitrator in a dispute between book authors and their publisher. The authors had signed a contract with the publisher concerning the publication of their book. The parties had agreed that in the event of a dispute arising, this would be resolved through arbitration, and that is how the matter ended up going through arbitration. So we see that it's actually also based on contracts, and intellectual property being a contractual undertaking, such things have to come up. We also see this in terms of transactions involving industrial properties, meaning trademarks, patents, utility models, all those are industrial properties. And each of these and their respective legislations provide for assignment, which is the complete surrender of ownership of the intellectual property, or a license relationship where you're just giving someone the authorization to use your IP under certain terms and conditions. So such assignments or licenses have to be registered with the Intellectual Property Directorate and Uganda Registration Services Bureau in order for them to be effective. So interestingly, it's only the Industrial Properties Act, that is CAP 224, which gives the registrar powers to deny registration of an assignment or a license if it is considered unfair. As to what unfair is, the registrar may look at the terms and say this is constraining the assignee or it's constraining the licensee. I'm not going to register this assignment, or I'm not going to register this license. But there's no specific mention of resort to arbitration in the event of a dispute. So it goes back to the parties being the ones to decide in this criteria, as Robert said earlier. But nonetheless, with such contractual undertakings in the use of intellectual property, arbitration is seen as the most convenient route to take because of the multitude of advantages that it has over and above taking such matters to the courtroom. Thank you.
All right, fascinating to hear. Let's also bring in Robert to make it even more fired up. Because in world over, people are fascinated and about everything AI doing everything. We're even fortunate as a country in that we have one of our developers who has developed the AI model in Uganda. So even to make it probably more accessible to the people down here in Uganda. But from your take, this thing that we are excited about AI, does it also have correlations with arbitration? Robert.
Timothy, that's a great place for us to have this conversation. The intersection is huge and it's only growing. Why? There are different areas and ways in the very nature of now, code itself is protectable as IP. So start from the decision of, am I going to build AI? You're creating intellectual property in the way that Professor Hakos has explained it. Will you need to protect that IP? Now, that's the person who's going to build. What about the person who has intersection we see right now or one of the biggest areas of intersection we see right now is the disputes between the various creators of works and the builders of these large language models, the most famous of which right now is ChatGPT. So think about the New York Times. The New York Times has sued ChatGPT saying that ChatGPT should never have trained its large language model using the archive of the New York Times. The New York Times is one of the oldest newspapers in the US. It has such a rich archive. It is very well respected. Its value lies in that reputation it holds with the public. Therefore, its articles, to the extent that they are proprietary in nature, are intellectual property that belongs to the corporation that owns the New York Times. By scraping the internet to use and using that archive without the permission of the New York Times contends that OpenAI, which owns ChatGPT, has violated IP. That right there is a dispute. Same thing with Writers Guild in Hollywood and various creators of music, creators of art, and so on and so forth. So you have the creator of art who is saying, do not use my art to train your large language model. You also have the builder of a large language model who is saying, no, what I am using is available to the public. And so you're going to have a stretching of the principle of fair use in copyright law. Then you also have those who are saying, I built a proprietary thing and I need to make sure that it's protected. And then taking the example, for instance, of a gentleman called Dr. Taylor, who different rights of IP in different jurisdictions. Taylor has tested and stretched the limits of patents, and I believe it's only a matter of time before we go to industrial designs. So, a few points. One, if it's capable of protection, it is capable of theft. If it's capable of theft, it is going to lead to a dispute. If it is out in a decision, there are property issues here with regard to who owns what. Large language models need data. Most data by its nature is protectable. So there's a huge intersection there. Then there's those of us who are advising clients who are creating data and creating IP. So the first intersection is the potential for disputes. The second is the opportunity in the industry. If you are creating data that can be utilized, or if you are using a large language model to create IP products. Okay, sorry. Someone has said, what is an IP? By IP, I mean intellectual property. And this is what Professor Kakoza has described earlier. If you're using a large language model or ChatGPT or artificial intelligence to create, okay, what is a large language model? I think I may have gone too far and left some people behind. Artificial intelligence, as we know it, is basically teaching computers, in very simple terms, teaching computers to execute tasks that ordinarily are the preserve of the brilliance of the human mind. The process through which we do that takes different stages, and oh dear God, this may need a slide, which I don't have the time to pull up. So you have, generally speaking, artificial intelligence, where you're training a computer to do things that humans would usually do. Within that field, you have a field that is called, you have different fields, and one of those fields is generative artificial intelligence. By generative artificial intelligence, you're talking about building computer models that can process information, large chunks of data, much faster than the human mind can process, and can execute tasks much, much faster. Those models are called large language models because they are able to take data and break it down from just ones and zeros to what should be in different contexts. For example, a video, a photograph, text, and all of that, synthesize it into one language, which then becomes text that is given to you. To do that, the underlying technology on which that is happening is what is called a large language model. Now, you would have a company that can have different models. For example, a company called Anthropic which owns Claude being one of the famous models out there, has different, what we would call LLMs or large language models, Sonnet 3.5, even ChatGPT started from GPT 2.0, and I believe we are now at 3.5. And I think from what I have heard, I think we are now GPT-4, and 4.5 is in the offing, if not almost released already. So for the person who asked the questions, that's the context. Now, in building those large language models, you need to train them on what is data. This is a man. If you've used Google before and they want to say, we want to know if you are human, and they give you 9 pictures or 12 pictures and say, select every picture with a motorcycle. Basically, what you're doing in clicking those motorcycles, you're teaching a computer how to see, this is a motorcycle, this is what it looks like, this is a horse. That is training. Only that on the AI side, it usually happens with massive volumes of data and happens much, much faster. So if you think about intellectual property as being this intangible asset, which in and of itself by its nature is data, that is proprietary, whether it's a song, it's a patent, whether it's a song, an invention, an art piece, or whatever, can you use this language model to create it? And if you create it, can you protect it? The courts are divided in different parts of the world. That's where lawyers now step in to say, okay, wait a minute, let's help you resolve that issue. So that's why the opportunity for dispute resolution lawyers is. Then you have the question of, okay, local example. Let me learn from Professor Goes and use a local example, which I think will drive the point home even better. A local artist called Azawi sings a song called Masavu. That is IP, it's intellectual property, because that song is capable of protection. Azawi happens to be a member of Swang's Avenue. Okay? Swang's Avenue is a collection of artists who ordinarily, as I understand it, basically are under one label. Who owns the IP? Who owns the song? That's a question for them to decide. Now, some clever young man goes out there, sits in his bedroom, throws this thing in ChatGPT, and does a rendition, including the voice of Mose Radio, who is now deceased. Azawi has chosen, so far as I'm aware, to not pursue this claim for, is there infringement? Has this person stolen Azawi's intellectual property? If so, which property? Is it the song? Is it the lyrics? Is it the production? What is it? If there is intellectual property and there's a violation, where do you go? Do you go to a court? Do you go to arbitration? The point being, eventually these questions are going to start popping up in arbitration. I want to leave it at that for now, and I'm happy to take any questions. But the points I'm making there, Timothy, were maybe 2 or 3. 1, yes, there's a major overlap between IP and intellectual property and artificial intelligence. 2, that overlap is at different layers. 3, it affects different stakeholders, whether those be creators, users, owners of intellectual property, or judges and arbitrators that will have to determine these disputes. If you have a contract in which dispute settlement is, think about an author, think about a script writer, the Writers Guild, the artist, the writer who writes for a particular movie project. Think about a show like 24 or Suits or Prison Break. Usually you'll have different writers. Each of them has a contract with the studio that's producing the show. If that contract has arbitration and this person wants to claim and the studio has taken the rights to lodge that claim, what happens? These are the questions of today.
All right. Many thanks, Robert, for that in-depth response. I just want to go back to Dr. before I come back to you, Robert. From Robert's explanation, has already given us citing local examples that are happening, right, of people who are making IP protectable works already going, you could say, on the treatment of being abused. We know of many people also who do photos. We've seen stories of AI creating these photos, but not them being fully original photos. We've seen same things for songs and many other works. But amongst ourselves, or that those who are already working for these persons or entities that create IP protectable works, and there are those who aspire to work for those persons or entities that make IP protectable works. So in line with what we've shared so far, and of course you affirmed to us that indeed there is a relationship between IP
Timothy, I think I've lost you. I don't know if it's from my end.
No, I think I've also lost him. I think he's frozen.
Now?
Yes, you're back now, but I didn't hear your question.
Oh,
You
sorry
froze
about
as
that.
you're giving right.
Well, yes, but just summarize it. Like we've heard from Robert and yourself, there is a relationship between arbitration and IP. So for us who want or who wish or aspire to serve with firms or persons that do IP protectable works, how should we adapt to this new reality of the fact that we can correlate IP and arbitration? How do we adapt to that so that we are not victims, but victors of the circumstances?
Okay, great. So it's a very interesting question, and it's good that it kind of flows from what Robert has just pointed out. The key thing being that AI, artificial intelligence, is actually intellectual property. It's a creativity of the mind, which is our understanding of intellectual property. So in building up on how we can be of service in this area, it starts with how are such issues arbitrable? If an AI system has been created and it creates the kinds of problems that Robert has laid out, one needs to understand how the AI system operates. That's the first and foremost thing, because when we're thinking about whether it's arbitration or using the adversarial system of taking such a matter to court, that I am a Zawi, I have my music, but now so-and-so is playing that music out there and it's established that it's an AI system that is playing it. Who am I going to sue? So it's about how to resolve this dispute, whether through arbitration or whether through the court system. So intellectual property is created by human persons. And I said that already. Although we now have, of course, intellectual property that is also created by artificial intelligence, especially the Dr. Thaler created AI that Robert has mentioned. The key thing to understand is that with machine learning, as an aspect of artificial intelligence, the AI identifies patterns and varies its algorithm based on already existing data and user feedback. So the keywords you should understand here is existing data and user feedback. So that's what feeds the AI system. There has to be existing data, or you have to feed it with data. And the feedback it gets on how it's using that data is what makes it become better along the way. So it grows on such information. It is through these mechanisms that the AI system is able to perform its tasks that would otherwise require human intelligence. So another subset of machine learning is the use of predictability. As you feed it with this data, it starts working out ways and means of understanding that if 1 + 1 is equal to 2, as I've been fed that information, that means all along the way, whenever I add 1 to another, it's going to equal to this. Every time I see 1 + 1 is going to equal to 2. Every time I see 2 + 2 is going to equal to 4. So it begins to understand predictability. And all you have to do is just feed it 1 + 1. It will figure out the rest of it. That's the machine learning process. So the digging up of data by the AI system is based on statistical tools or a generation of precedents that can inform it as to how, for instance, similar disputes in the past have been resolved. The AI system then uses this to simply substitute figures of the present from those of the past in order to come up with an actionable insight, or in other words, to give you the outcome of a dispute. So you have John having a dispute with Stephen. They feed this information into the AI tool. The AI tool will start figuring out how have similar disputes been resolved in the past. My prediction is that this is the direction that resolution of such a dispute should go. And that becomes the service provision of the AI tool and how it could be used in an arbitration matter. I hope that answers your question anyway.
Yes, very well, it does. Thank you, Doctor. Going back to Robert, from a position where someone is working for or working with AI entities, you've already given us the examples of OpenAI and the pending lawsuits. How do we position ourselves to safeguard such clients or to be of service to such clients who are in this AI industry with the glaring risks of the violations of IP as we've heard of and arbitration itself.
The question about positioning oneself often comes up, and I start with the point of, number one, learn this stuff. That's the starting point. The thing that is common in arbitration in artificial intelligence conversions is, but how does it affect me? Let me tell you, whether you are paying attention or not, artificial intelligence is affecting your life in ways that I can't even begin to explain on one call. So the starting point is learn the basics. The second point is decide what you want to use it for or how you want to work with it. I, for example, have played around with a few models and I have decided which ones I want to use for writing, which ones I want to use for fact checking, and for different purposes. The tools are so many, they are so different. You would need to know what tools am I using and for what. Even in the arbitration process, for instance, are you just using the tool for note-taking? Are you using the tool for sifting through data? Are you using the tool for drafting claims and arguments? Which tool are you using and what for? In learning AI, you'll discover that one of the most important skills anyone will need or needs today, not even will, but needs today, is something called prompt engineering. The ability to ask the right question in order to enlist the right answer. People who master how to ask these tools the right questions will be sort of at an advantage. Then there's the whole question of, okay, do I build my own thing or do I work with what exists, and if so, how? Now, take the example of Mr. Chitaka, whom you mentioned, who I believe has built Luganda GPT. There are things that were sleek to do 5 years ago that are unnecessary now. The base of the technology already exists, but you have to customize it to build the tools that you need. You're a law firm. You want to build a tool to resolve a particular problem. You don't have to start from scratch. Don't reinvent the wheel. So in terms of, if you ask me, how do we position ourselves? One, we need to decide what skills we have. One can say, I will just position myself to mediate and arbitrate disputes on AI. The other will say, me, I'm going to learn everything and be an expert witness. Another one will say, I'm the guy who argues, or I'm the lady who argues every case concerning AI. Of course, the most obvious is, how do you advise on a contract relating to AI? A client wants to buy a tool, but you're concerned, wait a minute, what comes out of this AI? Who owns it? An employee builds a tool at the workplace. Who owns that tool? Is it the employee? Is it the organization? Your general counsel, you're going to have to advise on that position. And the tool, but by the way, is artificial intelligence based. Number three, you're going to have contractual performance issues, and then someone is going to say, oh no, but I relied on an AI tool. And how do you deal with those questions that arise and surround? That's the thing. The AI itself is so huge, so diverse, that you have to look at it from different angles to be able to decide where to enter. So pick your entry point, decide what you want to do, master your craft, and then the world will be this path to you. I hope that answers your question, Tim.
Thanks, Robert. But still staying with you, there is something that probably could say is either unique or coming out strongly in the field of AI and these disputes. Just to relate, when DeepSeek a few weeks back was a banger, the US president did respond and say, we are not doing enough. And of course, this DeepSeek is merely stealing from OpenAI. So let's wake up. And we also know that what is really dear to these entities is the code behind whatever they do. So how do we, if we are to take the arbitration road or have any disputes or safeguard against them to prevent, how do we enable the
Oh, Timothy, you're hanging again. Timothy, sorry, I lost you towards the end of the question. You said, how do we what? When you were saying how do we, that's why I lost you.
so my question is, can you hear me now?
Now I can hear you, yes.
Yes, I was saying so. Since we've had these claims of literally stealing to support a plane, people saying this person stole stole our code. That is why they are building DeepSeek at these many levels. So how do we ensure the confidentiality when we are interacting with AI and probably these potential disputes?
So you picked a very good example, but also a very complex one. And I say complex because to answer your question using that example, I'm going to have to get into some specifics. And DeepSeek is the best example of ironies in AI because ChatGPT, quote unquote, stole from everyone to build a good large language model. Then DeepSeek came and, quote unquote, stole from ChatGPT to build a more efficient model. There's arguments, technically speaking, as to whether DeepSeek is better than GPT or whether they're just. What is clear is that one took from the other and built and made something more efficient at a much smaller cost. Now, why I said that I have to get into some specifics is the question of ownership and therefore confidentiality of the technology underlying these tools is slightly different with OpenAI. The way that OpenAI is structured, if you read the memorandum, if you read what is called the Articles of Incorporation or the Charter, for what in Uganda would call the MEMATs, the Memorandum and Articles of Association, OpenAI was set up for the single objective of benefiting all of humanity. It was not a for-profit entity. Okay? Now, therefore, everything they did, a significant part of what they did, they said was open source. Anybody can use to build. At that point, the moment you make something open source, you've traded confidentiality for improvement. The reason why you do that is you're basically recruiting 3 billion people to improve your product at no cost. And why GPT took the world by storm was it was the first of these tools to go public. I don't think it was the first to exist. I genuinely believe that Google has far more advanced tools and has had them for decades, at least 1.5 decades. Really advanced AI tools that they haven't made public. It was clear that Meta, or Facebook as we knew it then, always had these capabilities. They just didn't make them public. And indeed, that's why once GPT went live, everyone came back with an answer. Llama for Google, Meta released its own large language model, and so on and so forth, because these things already existed. But they were confidential because those were private companies. So, step one, if you want it confidential, do not make it open source. Step two, it comes down to your contractual framework and who accesses it. Okay? Now, if you write contracts with people who have access to these tools, then in the end, that's the closest you will get to confidentiality. Step three, whatever you don't want the public to touch, do not make public. If you think about Microsoft, for instance, Microsoft is one of the biggest backers of OpenAI. Microsoft, I think, by 2022 had injected $1 billion or slightly more than $1 billion. I think it's now much higher, the figure. I haven't checked lately, in OpenAI. And it's one of the reasons why OpenAI has such a high valuation, in excess of $80 billion. But Microsoft also has a product called Copilot. So what's happened is that there's an underlying contract between Microsoft and OpenAI. We give you money, you go and build stuff to go help the world, you give us the underlying source code. Now, those sorts of contracts are where you're going to find disputes on IP. Did you use the source code for what we agreed you will use it for? Now, in any license, and then we're going to come to licenses. In any area where you have people agreeing to use technology or data or any intellectual property or fruit of the mind for limited reasons, confidentiality is absolutely crucial. The question of violation is going to come down to field of use. What did we agree you would use this thing for? Did you use it for that purpose? Again, I repeat for emphasis, the idea here is you did not make it public. Now, let's also remember that OpenAI, you have a contract with OpenAI if you have used GPT-4. You just never read the contract. It's called the terms of use. You agree that we have a policy on how we use your data. You agree that by giving, here is another way where many people get involved. When you go to OpenAI and they say, do you want to create an account? You say yes. And then you to ChatGPT and say, do you want to, yes. Do you want to sign in with Gmail? What you forget is that there's another contract with Gmail saying, oh, we are going to make your data available. And so Gmail will now, Google will now come say to you, by using your whatever, when I was signing on to this call, I sent the link to my Gmail account, and Google, I tried to do it on my phone, and Google said, you agree that by clicking this button, we will give your data to Zoom. There's a labyrinth of contracts involved here. There's my contract with Google, my contract with Zoom, and so on and so forth. Somewhere in the middle there is my data, is my IP, is... So if you think about that in the artificial intelligence space, anyone who owns tools for AI-based tools, if you don't want to deal with confidentiality, don't make it public. Number two, if you use it, have a robust contractual framework around it. Number three, any service provider you give access to should have strong confidentiality provisions that you can enforce. Number four, a world that many of us haven't paid much attention to is the business and law of intellectual property and patent licensing. How you license IP and is very different from how you sell it. And that's a whole world, which frankly, I'm not sure that we have the time to get into on this call. But I hope that helps us to tease out the issues.
Yes, it opens up so much in our minds. And I want to go back to Dr. who initially intimated that he had the opportunity to arbitrate an IP matter. You've listed, you've mentioned some of the things to look out for. So I want to ask Doctor, when you're arbitrating IP disputes, which of course we've seen IP and AI also heavily correlating, are there special things that you should be aware of, or it's fairly business as usual, as in the other fields of arbitration?
Interesting. Thank you, Timothy. I was just listening in on Robert's articulation, and very interesting one. I wanted to first supplement what Robert has said, that we do not know how we're tying ourselves onto contracts whenever we're downloading all sorts of softwares. I've always emphasized this in my class, that people need to appreciate click wrap agreements or shrink wrap agreements. The click wrap agreement is the one that asks you that, do you agree to this and this? If so, click on the small button below. And when you're doing that, you haven't read the multitudes. And I've had the opportunity to interact with some of the lawyers who draft these agreements for software companies. They intentionally make them at least 10 pages long. They intentionally make them size 10 font, that you won't bother to read all this stuff. You just want to go right down to the software. You want to enjoy TikTok, like your friend has been telling you about the beauties of TikTok. You just want to get over with it without realizing that you're sharing data, you're sharing your Gmail account details, you're sharing your phone contacts and all this information. So we're getting to embrace, now people are getting excited with, I think, iPhone 16, which has an integrated AI system. And they have now come up with a simpler version. I think they launched it a few days ago, a cheaper version of iPhone 16, which also has, what they bring to the market with that is it has more AI within it, which means when you get all this information squeezed into one phone gadget with thousands of patents there and so many software tools to make it work, you are effectively giving out a lot of information. So think about probably a business person or a lawyer who transacts on his computer and it's synchronized with his phone, and you are sending out sensitive information over your phone through emails, and you do not know that you're actually releasing a lot of data that is quite confidential. And then you think that, oh, I'll be able to handle this arbitration as I travel. And yet arbitration has confidentiality in it, but you're giving out this information without realizing that the software tools are there to mine this data and relate to supposedly advertising companies, but there are others integrated within it that will find a lot of value in such information. So that was my supplement to what Robert was saying. Getting back to your question, how can we use, if I understood it well, applying existing IP tools or principles within the arbitration space to handle unique context AI systems? Is that what you're asking?
Yes, that is correct, Doctor.
Okay.
What you yes.
Right. There's no need to really think about reinventing the wheel in this regard. And I think I noticed that someone asked a similar question in the chat, that if I position an AI system to summarize an essay for me or summarize something I'm trying to put up, would that summary belong to the AI or would it belong to me? I think that's kind of related to it, especially if, say, a dispute arises. You start by looking at what is the legal system in place to help resolve any likely dispute in such a regard, or dispute that comes from such created works that have been generated by an AI system. So of course, we start by looking at the intellectual property laws. The current intellectual property legislation in Uganda does not allow for artificial intelligence ownership of creativity or of intellectual property. We need to get that straight. So starting with copyright, for the non-lawyers on call, a copyright is something that is established out of literary works, musical works, artworks, but the important thing being that what is protected is the expression put into a fixed form. I would have to put it into any kind of fixed medium. If it means getting the recording tools on my phone and recording myself singing, that is creating a fixation. If it means writing it on a piece of paper, that is creating a fixation. Anything I create or express and put into a fixed medium, the copyright kicks in. So imagine that person who has projected an AI tool to come up with a poem. Is he the one that owns the poem or is it the AI? And if we look at our specific legislation on copyright, which is the Copyright and Neighboring Rights Act, it says that an author is the person who has created the works. It defines an author as a physical person. So that's the end of story. Physical person is not an AI tool, so the AI cannot own copyright in Uganda. Let's take it to another type of intellectual property. If I want to market my business, and in marketing my business or building up a brand, I'll create what they call a trademark, because the trademark is either a sign, symbol, or a mark that identifies with the source of the business that I'm dealing in. So if this is created by an AI, would the AI register the trademark? Because trademarks have to be registered at Uganda Registration Services Bureau in order to be identified as trademarks. And when we look at our Trademarks Act, it's also clear under Section 6 that a person, it uses the word person, who claims to be the owner of a trademark is the one to apply for registration. And even in the simplest English language, a person cannot be an AI system or machine learning system. So as far as copyright and trademarks are concerned, in Uganda, you cannot have AI systems owning intellectual property. However, it gets a bit interesting when we turn to other types of intellectual property, specifically patents, which come from inventions. If I invent something technical, which is supposed to be a technological solution, let's say we never had motorbikes and I invent the first motorbike in Uganda or in the world, I would need to patent it. That's the legal language given to the intellectual property right that comes with it. And Robert has authored an interesting article he gave me the privilege of reading that argues that artificial intelligence can actually own intellectual property, and he was alluding more to patents. And when you look at the legislation in Uganda for patents, that is the Industrial Properties Act, under Section 16, it simply states that the right to a patent belongs to the inventor. So the right to whoever creates something technological which is worthy of a patent would be the inventor. It doesn't choose the word person, it doesn't choose the word physical person. So someone would probably come out and argue that an inventor can be an AI system, and therefore an AI system can own a patent in Uganda. So where arbitrators come in, there's a need to carefully understand such ownership principles as laid out in our legislation. Again, with Robert's article, talks about the Dr. Thaler's situation in the United Kingdom and in the United States. They have handled such ambiguities, which are also in their legislation, and they've been able to address them through two specific cases that came out both in the United States, as well as the US state was over a patent, I believe, and the one in the United Kingdom was over a copyright, or maybe it's the other way around. I don't remember. But in both cases, they said much as the legislation is not specific on the ownership, an AI system cannot own intellectual property. So they've kicked this out in the UK, they've kicked it out in the US. They're still studying the situation, but as things stand now, it can't be given ownership. The different position we have is in South Africa, where the same Dr. Thaler was allowed to get a patent for an AI-created invention. But if you dig deeper into what the patent was given, the South African legislation does not go into, I'm trying not to get too technical here. So when you're applying for a patent, you are either given, you're first of all given a formality examination report. Now, so the formal examination report is just like ticking off that have you satisfied document A, document B, document C? Do we have all these documents? And that's the intellectual property office. Then they get back to you with a formality examination report saying, yes, you have given us all those necessary documents. Then after a while, you get what they call a substantive examination report. Now, the substantive examination report is to see if for the invention you're applying for, does it have novelty? Is it really new? That nowhere in the world have we seen anything of that nature. Secondly, is there an inventive step? Have you gone an extra mile into inventing something that no one would have thought about? And the people who are doing this examination are experts in that very field. They look into your application and say, we could never have figured this out. We could never have thought this out, but we now understand how it works. So then inventive step is given, yes. The third requirement is industrial applicability. That is your invention industrially applicable? Can it be applied in any kind of industry where it would fit? So if you fulfill those three requirements for novelty, inventive step, and industrial applicability, you get a substantive examination report in your favor, and the patent is granted. Now, South Africa does not go into looking into the substantive examination report. They look into the formality examination report, which is where Dr. Thaler submitted the AI-created invention and fulfilled all the requirements for the formality examination report. And they said, okay, patent can be given on this basis. And he walked off happy. So technically, we can't say he has fulfilled the substantive examination and therefore the AI system owns the patent in that regard. But going back to the general nature of the question you asked, we cannot start thinking about arbitrators in the realm of disputes between AI-owned IP and users of such works, because in the legislation in Uganda, we don't favor intellectual property to be owned by AI systems. Thank you.
All right. Many thanks for that in-depth analysis, Doctor. We just passed the hour mark. I would like to thank the dozens who are sparing this afternoon and spending it in a learning session with us. You see many of us, including our chairperson for SEAB Uganda chapter, Mr. David Kagwa. We've seen partners at law firms, Mr. Rebecca Nambi. We've seen students, seen people from off the continent, Mr. Derek Kizito, and many more. We're very, very, very grateful for you sparing time to be with us. Just housekeeping, we'll just please keep your mics mute When we are done, we'll have a chance for those who want to ask their questions on the floor, and even those who are sharing their questions in the chat. Some of them are being answered in real time. If we miss out, of course, within the Q&A, we will have the opportunity to read that out for our panelists to have those questions answered. But many thanks for the dozen that are with us this afternoon. So I want to come back to Mr. Robert Chirunda, and I want to look in this second hour whether the remedies that we seek out for when we are dealing with these items of IP, AI, arbitration, are there unique remedies that we might be looking out for at the end of the day? Or, like they say, probably at times, many of our regulators sound helpless when some of the complaints are brought to their attention. They literally seem like there is nothing that we can do. But is there something that we could do? Is there a particular remedies that we could be looking out for when we're undertaking arbitration in the spaces of AI, IP? Robert.
So, thank you, Timothy. You raise such a fundamental question. I am resisting the temptation to jump back into the discussion that Professor Kakos has opened up to, but I would just say that the question of AI-owned inventions is fascinating to look at. I'd encourage anyone interested in this conversation to look it up. It's and I think someone was asking, my paper is only yet right now going through the publishing process. I will make it available as soon as the publishers approve it. Now, to your question about remedies, the starting point is don't look for the complex new remedies. Start with the ones we have. The easiest remedy to infringement is compensation, right? However, where I see the real riddle is beyond compensation, then what? It will become difficult. You see, in one of the obvious remedies was Anton Pillar, for example, where I get an injunction to say, oh, first stop using my IP, now give me all the records so that I can tell how much benefit you've drawn from it. It is so complex in AI because once the data is in, you can't really truly say the result is only because of that data. Do you see what I mean? So think about a caller tune. If I use, what song? I'm trying to remember one of Chameleon's songs, Bayuda. If I use Bayuda as a caller tune without paying Chameleon, then there's going to be a problem. He's going to come and traditionally he would say, get an Anton Pillar order and wait for the final remedies and get compensation, get an injunction to stop me from using that song ever again without his consent and whatnot. That framework applies on AI only to an extent. Now, the question is, how creative will we get? I honestly believe that the full answer to that question is yet to be determined because of the complexity of the question here. Remember that once this data is put on the table, it's integrated with other data and the machine keeps learning. So whereas you would easily say, oh, I want a permanent injunction, the data is already in. So how do I take it out? It's already evolved within nanoseconds of throwing something in ChatGPT. Before it gives you an answer, it has processed it and infused it in this ocean of data measured in petaflops, which is just, I think the computing power of GPT is measured in 1 to the power of 16 million. It's basically complex math. The speed at which these models process and the volumes, the velocity through which this data is going, you cannot use some of the traditional remedies, such as, oh, stop, permanent injunction. I can't. It's already in, it's in. So what may result instead is to, and I think it's happened in Russia where someone gave such a crazy award, and the point was, teach them a lesson. The biggest challenge that we have with artificial intelligence is it is stress testing the extent and the limits of our laws today. If you think about the foundational pillars of copyright, the foundational pillars of patents, the foundational pillars of industrial designs, large language models, or even just machine learning, is stress testing how far those pillars can stand. In fact, a professor at Stanford, Mark Lemley, has argued that copyright law as we know it today really has no place in the area of artificial intelligence. And he's done a whole paper on that alone. And he takes two pillars of the law of copyright and he shows why AI has basically wiped them out. The question then becomes, can you have a remedy if you don't have the background? So the complexity of what is going to happen in the next 6 months to 1 year, I think is yet to be determined. But I would emphasize, start where we are. Give damages if you find infringement. And to find infringement, you must go behind the model. And perhaps here, an interesting point would be to those who are litigating or arbitrating these questions. How do you determine a fact? You see, when you look at one of the most recent high-profile copyright infringement cases, the one involving Johnny Depp. No, there was one involving some keys, where, what's his name, this young man in the UK? He's sung some really famous songs.
Ed Sheeran?
Yes, Ed Sheeran. If you look at the Ed Sheeran dispute, thank you very much, Prof. If you look at the Ed Sheeran dispute, it came down to keys. And if I hear them, are they similar? This is the test. The training of the ear is one thing. Here you're going to get into, okay, can we audit the algorithm to see how did it arrive at this result? Now, I am going to argue my algorithm is proprietary, prove it. Let's leave the complexity questions aside in terms of, do we have the skills to interpret? Now, you're going to say, let's get an expert. And I'm going to say, yeah, but you want me to give my confidential algorithm to some expert because you're making a claim against me? So the layers of complexity are only growing. And I think that the more creative solutions are yet to be found, they will emerge, for sure. The one thing that we know for sure is that every problem has hidden behind it a creative solution. I would argue, though, that the ones we know right now would be to say the most effective would be compensation. Huge damages, hopefully to teach people, don't steal. Then there will be the question of what is the dispute that we are providing a remedy for? The last example I'll use is Spotify. There's been argument that Spotify is using its own artificial intelligence tools to create music and then index it and basically using AI manipulate the charts to put their music, which is not owned by anyone, at the top of the charts. Now, if I am an artist like Jose Chameleon and my song is ranking lower than it should, do I have a suit? And if so, what is my claim? Then you come down to what's the remedy? Can we realistically say that we will go to arbitration and order Spotify not to use AI? Or limit the scope of use? So that's where I'm coming from in saying the complex questions are going to emerge, the complex solutions. The complex solutions have emerged, complex solutions are on their way. And I think in creating
Thank
them
you.
lies. Yes, sir.
Thank you, Robert. I would want to turn the fire to Doctor. In addition to what Robert has said, of course, citing even authors saying IP no longer has a place in our modern world. And probably for IP practitioners, I think they feel most threatened by the works of AI. Just last year, the main characters at Hollywood thought that all they could do was go on a riot or strike or industry action and stop to perform. So would you literally agree with the statements by Robert that there is literally not much we can do? Or do you think there are remedies that can still help those in the fields that produce IP protectable material?
Very good. I have to just entirely agree with Robert. Starting from the point that do we have a place for corporate legislation in the future of AI? That's difficult. we have a place as intellectual property lawyers in the future? I don't know, because let me pick out two very crazy examples. About 2 or so years ago, it may be longer, it may be less, a song was released, which was a duet. And I saw the video, the video of that is probably still on YouTube. And this was a song done by Elvis Presley and his daughter. His daughter is now also deceased. But you have someone who died 50 plus years ago now doing a song with another person in real life. And many others have gone on to do such songs. Even the Beatles released a song about a month ago. The Beatles, if anyone knows the Beatles, this was a huge group that existed over 40 or so years ago. Now, in the copyright realm, what answers do we have for someone who infringes such music? The music that's being released is definitely artificial intelligence music. When we go to the legislation and what we understand about the legislation, we first of all look at the creativity, who creates, and like I said, for copyright, it has to be a physical person. And this is a principle we have picked from the first and oldest international treaty on copyright, which is the Berne Convention of 1886. It also talks about physical person being an author. Now we have dead people coming alive and creating music. Are those physical persons? No, it's the AI behind them that's creating. So the creativity itself brings in technological and legal headaches. Let's go then to duration. With copyright, once it is created in that fixed form, the duration of protection kicks in. If I'm an individual that created my song, it's going to be my life, and I'm talking about Uganda. It's going to be my life plus 50 years after death. That's the duration in which I would own the copyright. If it's owned by a company, it's going to be 50 years from publication. So it may be easier to say, okay, this company owns the AI that created the song that Elvis Presley did with his daughter. So let's look at 50 years from then. So you may have that slim gap of an argument to rely on that. But if it's an individual person, the people are not alive. How are you going to handle duration of such matters? So the current parameters of ownership and duration of protection of certain intellectual properties do not fit in with AI-generated works. And in case of a dispute arising, God knows how we'll deal with such a situation, because if it goes back to remedies, a remedy comes from an existing legislation, because it points out that this should be the remedy. But if the legislation doesn't speak into that question, then it would be hard to resolve it. And then let's go back to how does AI come into place? And forget about all this thing about specific companies that own different AIs. The whole nature or characteristic of artificial intelligence is there's discreteness, there's opaqueness in these characteristics, that you have different companies that come together and participate in the design, the modification, and the incorporation of AI tools to make the system work. So if it's the AI, we're not looking now at you cheating the AI or copying from it, but let's say it's the actual artificial intelligence that is infringing, as OpenAI has done, and all the copyright infringement cases against OpenAI that Robert mentioned. It's very easy for them to come up with a defense and say, how can you prove the specific infringement here came from OpenAI? Or OpenAI used company A, company B, and company C to come up with the different components that it then used. A corporate dispute is one, but a patent dispute is another. And in arguing patent infringements, you look at the specific claims. It's claims that make up a patent. Claim 1, claim 2, claim 3, all put together make a patent work. So if you're talking about an infringement of a patent, the best lawsuit you have is to say my claim 2 has been infringed. So if the AI system or owner says, but I don't own claim 2, or claim 2 was not created by us, it was created by a multitude of companies, then that's the discreteness I'm talking about here, where you may not, as the claimant here, who's seeking a remedy, may find it difficult to identify the exact loophole here that constitutes an infringement. It becomes very difficult. And the opacity or the opaqueness of how to handle such disputes makes courts hesitant to blame the end user of an AI system. If the end user is copying a song that Elvis Presley has done with his daughter, then how are you going to call that an infringement when you can't really figure out how it has caused harm to a fictitious party? So all those are the headaches we're seeing with infringements by or against AI tools. That the law, I can't even say it's playing catch up, because I don't know if it will ever catch up with such technological measures. Yeah, thanks.
Right. Thanks, Doctor. Going back to you, Mr. Robert Chirunda, like Doctor finishes that the law is playing catch up. But of course, just last year, if you wanted to remove UCDA, we removed it by hook or crook. This year, if you want to metamorphose the General Court Martial, looks like we're doing it. Isn't there anything that we can do to fix these regulatory gaps? Can't we run as fast? And what do you want to see fixed?
Well, I have argued elsewhere that in the age of the fourth industrial revolution, the legal regime we have, some people don't agree with me on this, but I have argued that the legal regime that we have is completely inadequate for the fourth industrial revolution, whether it's AI or data or blockchain or quad computing or 3D technology. The legal regime we have is just, I think it was built, and I can give you my main arguments here. There are really three. Number one, the regime we have that was built on the heels of the two major conventions has evolved from the Magna Carta to the two major conventions, the ICCPR and the ICESR, and the regime of property as we know it, mostly envisage the state as a guarantor of rights. The state cannot guarantee these rights in the world of technology as we see it today. Why? Because the state cannot police the big players. If you think about the oligarchy of 10 companies, Google, Facebook, Google Meta, OpenAI, X, formerly Twitter, Claude Anthropic, the chip manufacturer, why are all the names going out of my head now? The biggest US chip manufacturer, not TSMC's Taiwan, but there's NVIDIA. These guys have so much power and so much money, no government can correctly say they're regulating it. Anyone who wants to understand this point should read Shoshana Zuboff's book On the Edge of Surveillance Capitalism. What that means is that the legal regime today needs, for me, not to evolve, but to change. The process of changing that regime is not just about enacting a law, it starts with understanding how complex these fields are. Of course, there is the practical area of how do we reform it? What steps do we take? We prepared the National 4IR strategy, which I was privileged to be a part of, the process of which I was privileged to be a part of, in 2021. In that strategy, we made very specific recommendations on what needs to happen to solve this problem. How do we write a legal regime for AI? How do we write a legal regime for this or for that? Nothing has happened to take that strategy and make it policy, or from policy make it statute. Now, if you go back to the policy formation process, I've argued elsewhere again that the starting point usually is the question of strategic choices. What are you trying to achieve? What choices do you want to realize? Because you see, any statute you pass has trade-offs. If you now come and say that you want to put in place a law to regulate marriage, okay, you're going to have the people of the Islamic persuasion saying, whatever you do, don't tinker with us being able to marry, men being able to marry 4 wives. Then you're going to have pastors who are saying, but first wait, where in the Bible does it say I must marry only one? I think one pastor has said, show me the verse that says I must have a wedding. This, I believe, was Pastor Male. The resulting document from that will be a compromise of trade-offs. Every statute you pick up is a compromise. What should inform those trade-offs therefore? That's the deeper question. We need to first go through understanding, do we want to become an AI hub? Do we want to become AI consumers? The mistake we make is that we delay too long and others run way ahead of us. But don't even think about Uganda. Let's use the example of the US. The Biden administration had a very detailed position on how to go about regulating AI for safety. They focused on safety as their main trade-off. On day one, Jan 20 this year, one of the first executive orders President Trump signed was rescinding that executive order that President Biden had put in place. They've gone and said, oh, no, we want to focus on spurring innovation because that's the heart of Silicon Valley, right? So you can see trade-offs. Is it safety? Is it innovation? Those are trade-offs. How do you reconcile those? Then you can go to, now let's regulate. By the way, the theory has always been, ever since the Reagan days, let them operate, let it work, then it grows, then it becomes big, then you tax it, then you regulate it. So people will say, oh, we need regulation, but the question is not that simple. The other part of doing an AI act, that's the first part I've dealt with, doing an AI act. I would say we do, but start with choices. The second question is, what do we do to modify the statutes today? Think about the question that Professor Kakoza and I have been talking about. Should algorithms themselves own IP? I've devoted 25 pages of work to that question. My view, to which I bind only myself, is yes, they must. When I've debated professors on this point, they've said, oh, no. How does an algorithm, which isn't a person, own IP? And my first response is, wait a minute. Google is a company, it owns a patent. A company is not a natural person. So what's the argument for a company being able to own intellectual property, but an algorithm can't, if both of them are artificial persons? The deeper question is accountability. Who do we hold accountable? There's solutions for that, and we propose some of those. These are the questions we should have. So if you look at the current framework today, you need to do a gap analysis and say which laws are most affected. I would argue, you know, out of curiosity, I went and found out how many statutes does Uganda have today. The red volumes have 350 acts of parliament, the latest version, if I'm not mistaken. I would argue that every single one of those laws is affected somehow. Now, do you say we amend all the laws? That's impractical. So the result is going to start from soft legislation, policies, working documents, papers, guidelines. Bank of Uganda is good at this. Cybersecurity guidelines, which have no force of law. Since 2011, we are still working with consumer protection guidelines after all these years. 14 years and we're still on guidelines. This is the problem. Do we need to move faster? Yes. But in doing so, let's be cautious to not overregulate and end up passing a law on which car you can drive at what time, thereby just inspiring people to buy 5 cars so that they have the car for every time of the day. If the laws are going to be effective, they should. And by the way, to point out also, you have
Sorry, we seem to be losing you a bit there. Doctor, can you still hear well from Robert?
No, his video is frozen.
to copy data. We didn't do a very good job with GDPR. GDPR is far more.
He's back. Sorry, Robert, we lost you for a minute or two there.
I'm not sure. I'm not sure what happened, but I seem to have dropped out. I wonder where you last heard me. just so I can wrap it up.
I think you're mentioning something about ChatGPT.
No, I think I had finished ChatGPT. Dear God, I've lost my track of thought. I was saying that I think I had gone to GDPR to say that even on a copy, we don't copy too well. The Data Protection Privacy Act should have helped us with data protection, but instead what it has done, our DPPA is far behind GDPR. And by the way, I think somewhere around section 28, for example, I don't have the DPPA right in front of me, but you will find that if you look at our act, it does have anticipates the use of artificial intelligence. Specific provision on artificial intelligence. So yes, we need to see what's happening elsewhere, update where we are, forget what's happening at the AU. In my view, the AU is just not serious what they're doing. But we need to move in some direction and to be more deliberate. It's a question of choices. If we want to bring investment here, we do what it takes to bring investment here. We pass the laws that attract investment. If what we want to do is regulate risk, we do that and forget about investment. If what we want to do is try and balance safety versus investment, then we write a law for that. And that's how we end up where we need to go. And someone is asking about the book. The book, yes, was The Age of Surveillance Capitalism. But you're right, The Coming Wave by Mustafa Suleiman is a fantastic book. By the way, anyone else interested in this subject, The Coming Wave by Mustafa Suleiman, I would add for you another one, which is AI Superpowers by Kaifuli. Let me type it in the chat. If you had read AI Superpowers when it came out, you would see that it basically predicted DeepSeek versus ChatGPT. But I'll leave it at that for now. Thank you, Timothy.
All right. Thank you for that in-depth analysis, Robert. Doctor, to bring you back, Robert closes off by giving us a look into the future. And I want to bring you in right there to share with us what does the future hold? What do you foresee? What are the trends that we should be aware of as we are positioning ourselves in these newer sense?
Okay. I don't want to be so much of a Nostradamus here. Nostradamus predicted so many things which have actually come to pass. Some of them are yet to even come to pass. But it's not only a future trend that I see, but future challenges as well. Because artificial intelligence tools have been called disruptive technologies for the simple reason that many are resorting to them as a complete substitute for what humans do. And the question has always been, will AI replace lawyers? Well, now we're saying, will AI replace arbitrators? I don't see that as entirely happening, but there's definitely going to be an increase in AI tools being used in arbitration, for instance. It's not likely to completely or easily replace arbitration practitioners for a number of reasons. Arbitration in itself, the advantage that comes with it is the confidentiality in that. You're not going to go to a computer and type arbitration precedents and find a whole multitude of data. You'll find very few of these because they work on confidentiality. And since the chip that makes AI run is embedded in some computer system or has to be placed within there, then that's a limit in itself, that in text and data mining of AI systems to be able to generate how arbitrators think and how they work so as to entirely replace them, that's not going to happen. And this is not going to happen that easily because it won't be able to snoop around and find so much in that respect. And then when you also think about the cognitive skills that go with arbitrating a matter, what you have to think about, the emotional skills, I mean, what you have to think through before you come up with your determination of an issue. AI systems don't have cognitive skills. They don't think like that. So that's not going to help as well. But then we have something else to worry about. AI can be problematic if it's given full control. of an arbitration process, because there are people who are saying, going back to what I said about disruptive technologies, that if I can use my AI tool, feed it with all the necessary information, can't it be cheaper for me to find my dispute resolved or to predict the outcome of my dispute instead of paying some lawyers and arbitrators to help me resolve this? So remember that arbitration rides on, like I said, confidentiality. So on the other side, if people place this information into a system and such data is hacked into or misused by the AI system, this will not go down well with the parties involved. So it's more worthwhile to use artificial intelligence for research purposes, which is what it's doing, and summarizing of evidence or preparation of documents, rather than going all the way into being used for resolving of disputes. And then when arbitration practitioners who are using AI tools come in, they should always cross-check the case precedents that the AI tools are relying upon, because AI systems have been wrought for picking up fictitious, non-existing cases. ChatGPT has also caused problems, as Robert has pointed out, with the cases the New York Times and Writers Guild sued. These are copyright infringement cases. So the AI system didn't go through a copyright class to understand you shouldn't copy this or copy that, or at least this is fair use, or you should give attribution where you copy that. It just mines the data and gives it back to you without citing where it has gotten it from. And it's facing such challenges. So the tools are not yet that respective about copyright, and that is something that we need to be wary of when we decide to use AI tools in the nature of the work that we do, especially where arbitration is concerned. Thank you.
Yeah, many thanks, Doctor. We almost closing the Q&A. So just a reminder, housekeeping, for those who may want to shoot a direct question on the floor, kindly use the feature to raise up your electronic hand, and we'll be able to pick on you and give you the opportunity to ask them directly. For the rest of us, or if you don't prefer the mic, you can type it in. We're going to have a chance to read as many as time can permit us. But before we go there, I'll just want to bring in Robert to just see if there's anything that he would add on what he sees the future holding, if there's anything that he would wish to supplement on that, Robert.
So first of all, I want to express my most sincere gratitude to you, Timothy, and the team that's put this together, but also to Professor Kakoza for a most engaging conversation this afternoon. I think I'm enjoying every minute of it. And the subject is so wide, so deep, but we do what we can. The thing I want to comment on is something I hear a lot in AI conversations, and Professor Kakoza touched on it. Will AI replace individuals or even arbitrators? I first of all think that's already happening. If you think about it, if any of you has ever raised a claim with the PayPal dispute resolution engine resolves at least 56,000 disputes every year. If you think about it, that's more than all of Uganda's case backlog. It does so without human intervention. That's one engine. And those numbers might even be old. Now, dispute resolution will change. That's for sure. Does that mean we as arbitrators and arbitration practitioners will be relevant? No. Anybody who is concerned about AI and your job now should understand. It is not AI that will replace you. It is people who know how to use AI that will replace you. The example I like to use is there was a time when some of us were starting practice where every law firm had secretaries and I remember I did my clerkship at Shanobi Msoke. There was a typing pool there. I don't know if it's still there. I haven't been to inside Shanobi that far inside in a long time. But there were these people we called secretaries, whose job it was to take a handwritten document and turn it to ink out of a machine called a printer. Guess what? About 7 months after clerkship, 9 months after clerkship, I started at a law firm where there was no single secretary. Today, I don't know if anyone goes to school to become a secretary. Those people are replaced by laptops. We all have a personal secretary. We call them laptop. The result is we are far more productive, we are far more efficient, we are far more, we have a higher output, and labor as a factor of production is far more valuable. That's what's going to happen in the AI age. People who understand these tools, who know what to use them for. If you take, and I'm glad someone actually pointed out that the Silicon Valley Arbitration Association has, in fact, issued guidelines. The Mediation Center in Silicon Valley has, in fact, issued guidelines on the use of AI in arbitration. And you will see that they are dealing with principles, understand the limits, disclosure, respect, and whatnot. The New York Bar also, by the way, has a very interesting report that came out last year. I would encourage anyone interested in this subject to read it. It will give you some good insights on the use of AI by lawyers generally. I think that there are more opportunities than there are limitations, but we have to upskill to be able to understand and to see them. I also think that AI will create its own measures of value. By the way, towards the end of January this year, the World Economic Forum released a report on the jobs that are most endangered. The 15 professions that are at the risk of disruption by AI. We had always, as lawyers, been out of that list for a very long time. We have now made it to number 14. My prediction is that we're going to go up the ladder, but us being displaced is not the role of a lawyer. It is specific functions of lawyers. Another prediction from, I believe it's one of the big 4 audit firms, is that what will happen is new jobs are going to be created, and you're going to have a chief legal compliance, a chief legal AI officer, or somewhere between AI and the workplace. There will be a lawyer who knows those issues. It's the same thing with arbitration. There will be people who understand how to safeguard confidentiality, how to use large language models to process evidence better, how to lead evidence, how to answer the complex questions of what remedies do we give. Those are the new opportunities. And from where I sit, they're actually very many. Thank you.
Many thanks, Robert. I would like to first visit our Q&A. Some of the questions, good enough, you already reacted to them, but I wanted to pick out this one by Norbert Sally. Robert, you touched on it a bit, but just read it. It says, if I submit my report to an AI model to be summarized, who owns the resultant summary report? Can the proprietors of the AI tool claim proprietary rights over the summary report generated with their tool? That is from Robert Sally. To you,
Mr.
Robert.
Mr. Sally, the answer to your question from where I sit, and I'm curious to hear what Professor Kokoza thinks, has 2 starting points. Number 1, what do the terms of use say? Because some proprietors have said, we do not own this information. Whatever our model produces, we choose not to own. Others have said, you give us your data, know that we may extract it for value purposes and we'll use it for different purposes. That's the first point. What do the terms of use for the platform say? The second point is, what are you looking at as value? Because the issue here is you're looking at the summary, whereas what they are looking at is the ingredients of your report. Now, you cannot claim that this report that you threw in is still yours, because what you've done basically is put on the internet. Now, also there's a tricky question here on fair use. If we use this report to improve the way our model works, can the argument be made that that falls within fair use? Because we're not doing it for only our benefit, but for the benefit of anyone who ever interacts with our model. So that's how I would unpack your question. And I can keep going further and further. I guess the short answer to your question is, it depends.
Depends. Thank you. And then there is this one from Nanza. I'd like to throw it to Doctor. And she or he is asking for the regulatory contexts for AI, and I think he puts it in the East African context. I think just a regional outlook briefly. The Masavu song was already touched on fairly. So, Doctor, just a regional outlook of where East Africa stands from a regulatory perspective, please.
Okay, thanks. As far as I'm aware, we haven't gone far as the East African community on regulating AI. As Robert had pointed out, there are guidelines from the different, I think Kenya has probably passed. Somebody, Robert can correct me here. I don't think we've gone into any specific legislation on artificial intelligence in East Africa. Robert, do you have
Robert, a supplement to that?
No. Professor Makosa, to my knowledge, Kenya is the most advanced. We all started from. Sorry.
So, sorry,
I think Timothy is.
To be losing you a bit.
Prof, can you hear me? Can you hear me, Timothy?
Yes,
now we can hear you.
Hello?
Yes, we can hear you, Robert.
We can hear you
now.
Okay, lovely. I was saying that to my knowledge, Professor Makosa is right. Okay, fantastic. I was saying that there seems to be a delay, feedback loop on my end. But I was saying that
we seem to have lost Robert again. But just to clarify that Kenya has made some advanced steps beyond what the other East African partners are doing, but there's no specific legislation. So as far as what we call by advanced steps, they're probably guidelines from Kenya, but not legislation. Robert, you're back here.
Sorry.
Yeah.
I just switched internet providers because I think I was having issues. To my knowledge, where we started, Kenya was the first to issue a national blockchain and AI strategy. That's where they started, and that must have been, if my memory serves me right, this was early 2018. That task force that did it was chaired by a man called Professor Bitang Ndemo, who I believe is now Kenya's ambassador to Britain. Uganda followed suit with a national 4IR strategy. Kenya has now issued some sort of guidelines, and they have indicated they're heading towards an AI policy. But to my knowledge, that's not reached legislation stage yet. And that's the status I think after Kenya in the region, we are probably closest. We now have, to my knowledge, the UCC has a task force. So you have the national strategy. I know that at Ministry of Science and Technology and Innovation, there is a working group, a 4IR plus working group that's been looking into some AI issues. I know that at the Ministry of ICT, you have some work going on towards sensitizing people towards AI. And NITA, which is under Ministry of ICT, has been looking to convene thought leaders into one room to develop to think about and starting through an AI policy in Uganda. The challenge, of course, there is too many cooks can spoil the broth. But yeah.
All right. We appreciate you very much, Mr. Robert Jude and Dr. Makosa. I would like to bring you in to share with us your final remarks and the tips that you could want us to go away of this call. So, but before, after that, I'll request our chairperson, Mr. Kagwa, to give a vote of thanks. Before you bring you in, let me first bring in Doctor. Your closing remarks and the tips that you would like us at least have a takeaway as we prepare for practice in these spaces.
Thank you, Timothy. Again, I appreciate the opportunity. My tip is going mainly to practitioners in this area or people who are interested in becoming practitioners in arbitration or in the cyber law space. to say that they should adapt to the extent to which AI tools can be used to better their practice, as well as appreciate themselves with the many limitations that AI poses in the arbitration practice. So it's more like understanding your competitor, because AI, in one way or another, can be our friend to better our research and preparation of documents, but also wants to come in as a competitor in making things work where the human person would have been making those things work. So let's understand how it works and where would fit in the gaps much better in the future. So that's my tip, because the future trend is limitless. It's a black hole. Technology always surprises us because that's the nature of technology. But we should avoid the surprises being very huge against us. Thank you.
Hey, thank you, Doctor. I would like to ask Mr. Robert to share with us his closing remarks and the tips that we should go away with.
First of all, many thanks to everyone who stayed on the call this long. It's always an honor to have an audience. The Bible talks about a certain man who held a feast and he invited his friends, and each one of them sang him a song, "I Cannot Come." We are grateful to people who have taken their afternoon to stay with us to the end. I agree with Professor Kakoza entirely, and I'm grateful to my colleague for his very, very thought-provoking and insightful remarks on this call. I agree with him entirely. The first step is future-proofing. Whether you like it or not, this stuff affects you. So future-proof. But the second and the biggest tip I can give anyone on this call is this. Lawyers, arbitrators are not disrupted when someone builds a tool to do what we do. The biggest disruption happens when our clients are disrupted, because that's how the work goes away. If I could say everything I said, if I could leave everything I said today and give you one tip, that would be it. So I would say future-proof, take time, learn this stuff. It's important. It's not that difficult. Now you can actually build AI tools without writing one line of code. And the tools are so many, you have to know. Oh, the other tip that I would give you is pick your entry point. Because it's like, if you had to go to the airstrip for an event, the Colorado airstrip, before they built a perimeter wall and restricted points of entry, you could easily have picked whichever spot to enter in or where to stand. But the advantage you have depends on the vantage point of where you're standing. So we will all benefit or lose in this AI discourse depending on the vantage point we choose to take. Those who choose to take the vantage point of building bulwarks to protect the work today must remember that while Kodak and Fuji were fighting about film, the world went digital. And the day will come when, in fact, a friend of mine one time told me the same way on your desktop, you have different tools for Office, Office, Outlook, PowerPoint, Excel, PDF. The future is that you'll have another tool there of some AI thing, whatever that is, whether it's GPT-5 or Anthropic or whatever. That's how familiar we will be with tools. Lastly, do not fear displacement, because if you future-proof, that will not be a problem. Thank you for your very kind attention.
Asanteni sana Daktari Kakoza na Mheshimiwa Robert Chirunda. We are very, very glad to have learned from you for these 2 hours. We are very, very grateful for sharing with us, and we hope that this can only make us better and better as practitioners and as persons who travel this earth. And I would wish to invite our president for CIAB Uganda chapter, Mr. Kagwa, to give his vote of thanks.
Thank you, Timothy. I wish to thank you very much, Dr. Kakoza and Robert Chirunda, for this fantastic webinar. Thank you very much for Timothy for moderating. I wish to thank you very much, the participants, for tuning in and being part of this story. It's a unique story that we need to discuss further. We are planning an international arbitration conference in November. This conversation has been so intense that we have an intention of maintaining the same panel. So in case you were planning to go on holiday in November, that is to you, Dr. Kakoza and Robert and Timothy, please stay around for our conference, which I'll confirm the dates. You can go in December. And to all our members, thank you very much for tuning in. We have on the 7th of March, Women's Day event at Onomo. It's a CIAB collaboration with Africa Women in Arbitration. Please join us. It has very good speakers. We also have the introduction to arbitration on the 24th of March. Special thanks go to the Education and Training Committee of the Chartered Institute of Arbitrators that make these webinars happen, chaired by Anna Maram Singuzi, Mrs. Thank you very much for putting this together. And also thank you very much our Secretariat, which is headed by Bridget Masava, ensuring that the technology and the logistics are up and running. I wish you all a very good evening and see you again. Bye-bye. Over to you, Timothy.
All right. Many thanks, David. We're glad to hear from you and also know what's coming up. And of course, you're geared up to continue the conversations. Like Adia said, we have our social media platforms, CIAB Ghana chapter on X, on LinkedIn, on YouTube. You can always go back to those platforms, interact, and also review from the feedback. We probably could have jumped off somewhere, network connections. The recordings will be available for you to keep learning. And let's keep the discussions going. From me to you, it's a good evening, and I wish you the best. Cheers.
Thank you very much, and cheers to all.